Jacinda Ardern.
Mr. Chair, it's my pleasure to give a contribution on this bill. It's something I feel really strongly about as someone that's resident in the area where this convention centre will exist. And I fear that in all of the debate, that the overall principle, the debate around the existence of a convention centre or not, has definitely been blurred by the government. So I want to come back to that original question, because the government has continually maintained this line that it was either trade off the gambling harm issues to get the convention centre or nothing. Or nothing. That it was economic development via the Sky City Convention Centre and a bit of gambling harm on the side, or potential job loss and net economic loss to the country on the flip side. That is completely wrong, and that is completely misleading. Now, the rest of the country could be forgiven for having just that small view of this entire picture, because the government didn't talk about the other options on the table, because in reality, the Prime Minister never really considered them. And in fact, the government probably never really considered them, but they existed. In fact, many months ago now, I OIA'd what some of those options were. I had a personal interest in some of them, because some of them may have led to quid pro quos that could have been a net benefit to the city in which I lived, including the Aotea deal. And I want to go through some of those so that the public know that they're not having to be forced into the ridiculous situation of choosing harm for the sake of 18 jobs, when actually we could have had the convention centre without this dodgy deal. Now, back when it was originally floated, Mr. Chair, that the government was interested in a convention centre, that there was a belief that there was a gap in the market, there was an opportunity for some other options to be raised. Now, at that time, probably the most seriously considered were the likes of Ngāti Whātua, who had some plans for land that they owned, I believe on the waterfront was where they were originally thinking, the potential for them to then partner with council and government in the development of a convention centre there. The other option, which got a little bit of airtime, was the idea, Mr. Chair, that we have the entire edge-operated Aotea Centre in the middle of Auckland City. Some might say an underutilised resource, but a resource that has had, in recent times, significant investment in it. Now, there is a recognition at the moment that centre is fulfilling quite a specific job. That they do house, for instance, New Zealand Opera, New Zealand Ballet, and so on, and that if you did pitch the Aotea Centre to be an international convention centre, you may need to provide some alternative facilities. So the idea that was put forward, Mr. Chair, was that we could turn Aotea into an international convention centre, give it the alterations that it would require, and it would require some, and at the same time restore the St James to pick up the alternative role that convention centre therefore would no longer be able to provide. I only see win-win in a suggestion like that, Mr. Chair. We wouldn't have to pass law in this House to allow for additional pokey tables to come into play in order to have had that deal. And we wouldn't have had mass protests from the public who know what we are trading off in this House today off the back of that deal. But that's not the deal that the government chose to select. So be under no illusion that this was the only option on the table. It wasn't. Be under no illusion that the only way we could have had economic development and jobs was through this trade-off. It wasn't. And that, in my mind, Mr. Chair, exposes how dodgy this deal is, because there were other options. Mr. Chair, I want to speak a little bit to Part 1, Clause 3, the purpose and outline, which says that the overarching purpose of this Act is to provide economic benefits to New Zealanders by improving New Zealand's capability to host medium to large-scale international conferences and related exhibitions through the construction and operation of an international standard convention centre. To this end, the Act, and then it follows on, giving the agreement with Sky City. Now, as I've already said, very unusual to have to pass the law to build a convention centre in this way. But that therefore implies that, of course, the economic benefits were, of course, attached only to the Sky City deal. That's why I want to reflect, Mr. Chair, on the process that we got to in order to get to Part 1 in the first place. And in order to find that, I'd like to go back to some of the statements that were made in the lead-up to this, even, Mr. Chair.
Jacinta Ardern.
Thank you, Mr. Chair. Even before this even got to Select Committee, because we did have some analysis of the process that we got we went through in order to get to this place. So let's perhaps go through that process in which we established the economic benefit. In August in 2009, there was a feasibility study as to whether or not a new international convention centre would be of value, and it was MED and Auckland City Council. It was that time that I heard the vague discussions about this potential deal. It was in that same month that John Key was briefed on the study's findings, and officials recommended that there was a business case that sat around it. So that was in August 2009. We know then by the end of August, officials were made aware of a proposal being developed by SkyCity to expand their own convention facilities. Key then handwrites, when they were talking about the proposals and doing feasibility, handwrites, we should close off the SkyCity angle first. We should close off the SkyCity angle first. Now, if that doesn't indicate there's already an ingrained preference before any of this has gone anywhere, I don't know what does. By the end of that year, by the 4th of November, we know that John Key had dinner with the SkyCity board, and he says that they discussed a possible national convention centre, and they raised issues relating to the Gambling Act 2003. Now, that's an interesting point, Mr. Chair, because we are now debating the very amendments that back at the end of that year the Prime Minister was already talking about. But here's a really important point. The tender process hadn't started. Expressions of interest weren't called for until the next year in March. But already the Prime Minister was having discussions talking about regulatory trade-offs with SkyCity. Now, surely, if regulatory trade-offs were part of what the government was interested in entertaining in order to have the convention centre built, was that part of the tender process? Were any of the other interested parties told that if they were interested, they could perhaps put forward a package that wasn't just about building a facility and doing up the St James, but actually, for instance, Vector Arena might be interested in building another facility in exchange for some electricity regulatory trade-offs. But did they know that this was an option? They absolutely did not, Mr. Speaker, because this was a deal just for SkyCity specifically, and we know that from the timeline that's already been exposed. It was then Auckland Airport may have wanted to throw. There are a range, but we never knew about that. They didn't even know about that, Mr. Chair. We then, by that same month, when the expressions have gone out, the government suggests that the current arrangement with Auckland City Council to follow up the jointly funded feasibility study must end, even though $250,000 had already been set aside for the feasibility study. And in May, we've then got the open tender process. It was by September that SkyCity was asking the government to buy some of the land required in order to go ahead with the convention centre they were proposing. Now, I actually could go on. I've got pages and pages more of timeline, but as you can see, before the convention centre tender process had even closed, SkyCity was talking to the government about buying land to build its convention centre. Before the tender process had even opened, the Prime Minister was talking about amendments to the Gambling Act. It is no wonder, Mr. Chair, it is no wonder that the Deputy Auditor General said on the process, quote, "We do not consider that the evaluation process was transparent or even-handed." I'm going to read that again. I think it's an important point. The Deputy Auditor General, when she said, "We do not consider that the evaluation process was transparent or even-handed." This side of the House does not just throw around the word dodgy deal for nothing. We say it because the evidence exists. Mr. Joyce may lurch in his chair with what appears to be laughter, but I can't quite be sure. But these are the facts that are before us. We know from the timeline. We so very rarely see what could be anything other than a smug smile from the Minister. It's hard to know. We base what we have said around the tender process based on the facts, the evidence, the cabinet papers, the process, and all of it, Mr. Chair. all of it leads us to the impression that it was a dodgy deal. But, Mr Chair, it didn't have to be this way. We could have had the convention centre without that, and that's what we needed.
Denise Roach.
Mr Chair, I rise to take a call. My first